Hello friends, welcome. Friends, on 20th of July 2025, there was an article in the newspaper where it says that the DOT has issued a demand of rupees 7,800 crores on Tata Communication. And this article quotes Tata Communication officials, and they are quite confident that they will be able to defend this. You see, the company, based on the assessment of independent legal opinion, believes that they will be able to defend its position. So it says that they will not be required to pay this. Now, friends, this does not give the exact legal reason as to why they will be able to defend this. So this video is all about making you aware as to why these can be defended and why the company official is so confident about it. Okay, that is what I'm going to do in this video. Now, if you recall, friends, that Supreme Court in year 2019 came out with their AGR judgment, where the companies who were under the migration package, they were fighting the definition of AGR and they finally lost to the Supreme Court. And then in year 2020, the final preliminary demand of DOT became the final demand. And then the Supreme Court also came out with a payment criteria, which is 10 years with 8% interest. All the demands have to be paid, which were on the preliminary demands which were issued by DOT. Now, what happened was, when the Supreme Court judgment came in year 2019, and when the final preliminary assessment became the final assessment in year 2020, in the middle, DOT issued demand on public sector units. And they issued demand of a huge amount on public sector units because there was an interpretation in DOT that whatever judgment which the Supreme Court gave in year 2019, the same was also applicable for public sector unit because they were under the telecom license, which as per DOT were similar in nature. That is net. And Supreme Court got very annoyed with DOT, and therefore they argued this case, and the case was argued and an order was issued on, I'll tell you the date on which the order was issued. It was on 11th of June 2020. And if you look at this order basically is discussing the PSU matter, public sector unit, where the demand has been raised. He says that we have posed a query to Tushar Mehta, learned Solicitor General, how the demand was raised on the basis of a judgment with respect to PSUs. Licenses were different and judgment never dealt with the issue of PSUs. And then they go on to explain why the PSUs do not fall under the 2019 judgment. So I'm going to show you what the judgment says, and I will not go into each and every aspect of it. I'll simply go and I'll go down below, and here it is. Here in this para, if you look. So it says, Supreme Court is saying that it would appear from the text of the above definitions, which are basically of different type of license, ISP license, NLD license, ILD license, IP2 license, that the definition of revenue used in the USL and the ISP license as against the phrase used for the NLD and the IP2 license are different. You note this. The USL and ISP license were differently worded compared to the NLD and the IP2 license. Specifically, the phrase by way of providing services under the license. So, by way of providing service under the license was anchored in NLD and IP2 license, and the Supreme Court believes that this phrase prevents the NLD and the IP2 license from to be coming under the AGR judgment of 2019. And it says that has been used in the NLD and IP2 license to qualify the term revenue, while this is not the case with the USL and the ISP license. And further, from the bare perusal of the above, it is clear that the terminology other miscellaneous do not form part of the license agreement of the IP2 and the NLD license. This is the crucial paragraph which one needs to understand in order to legally defend why Tata Communications don't have to pay their dues. Now here there will be a catch here. I'll tell you what the catch is, because if you look at here, they're talking about USL and ISP under the same bucket, NLD and IP2 under the same bucket. So USL and ISP buckets actually have been made in brought in par, where the NLD and the IP2 buckets licenses are different. But here there is one more thing which the Supreme Court says, is that it is submitted that the PSUs form part of the class in themselves, as they substantially discharge government function and represent public funds. It is submitted that the liability of more than 4 lakh crores would fall upon the PSU and may not be larger public interest, and more particularly that these PSUs do not provide mobile services by way in which the commercial service providers are providing. The requirement of a license by this PSU may be based on some of their own internal requirements and not for commercial exploitation, the way in which the other telecom service providers require the services, except the two PSUs which are not mentioned in the list, which are MTNL and BSNL. So two reasons have been given. One is that most of the PSUs are holding NLD and IP2 license. Some PSUs are holding ISP license also. Those who are holding ISP license, they also do not form part of the AGR judgment, because they are doing non-commercial. They are not providing commercial services, right? Like other private operators are providing. But, there is a catch here, friend. I'll tell you what the catch is. Now, after this judgment, because if you look at first, let's look at what Tata Communications is saying. Tata Communications is saying that they fall under the ISP license and the NLD license. You see, it says that the demand notice, this 276.7 crores toward disallowance of deduction claim by the company on payment basis in the year FY11 under the ISP license and NLD license. Now tell me, if the NLD license do not fall under the bucket, then how the ISP license, which the Supreme Court is saying here, is actually aligned with the USL license, and the USL license and the USL license actually were covered under the 2019 Supreme Court judgment. So how they are able to get away from this word ISP license? This is important to understand. Now what happened was, friends, after the Supreme Court judgment, everything happened because the PSUs got completely bailed out, not only from the NLD and the IP2 license, but also from the ISP license because of this because they were not providing commercial services. So NetMagic was a company who raised their case before TDSAT, and I'm going to show you the TDSAT judgment. First, you look at this. NetMagic Solution versus Union of India on dated 20th February 2020 to 2020. So here, if you see here, you will find that the NetMagic Solution pleaded for the TDSAT that to seek quashing of 13 letter issues by DOT between so and so, raising demand of license fee based on AGR pertaining to the financial year 2005-6 onwards in the Mumbai service area against the license agreement with the petitioner dated 8/8/2002, right? So what is NetMagic case? NetMagic is a internet service provider. Now, internet service provider PSUs got completely, circumvented by the by the Supreme Court judgment. But if you are a private ISP operator, then you are not circumvented. Similarly, if you look at Tata, is a private ISP player. So they were not circumvented by the Supreme Court judgment. Similarly, NetMagic said that, look, I have been asked for DOT to demand to pay this, and I believe that I don't require to pay because I am an ISP provider and I don't need to fall under the AGR judgment. Now, what DOT is saying, what TDSAT is saying, I can show you. I'll go straight. We're not going to go into the details of the judgment. It says the following. It says that, if you look at this, the last para, in view of the aforesaid facts and discussion, the issue related to the prayer of the petitioner that the order dated, this order of the Supreme Court judgment 19/11/2020 be reviewed and given parity of treatment in respect to the concept of AGR by excluding revenue from non-telecom activities and services is found fit to be accepted in view of the stand and action of the responded qua of some of the PSUs having the same license for providing internet services. As a result, the impunge demand license fee raised by the petitioner by the DOT by including revenue from non-licensed activity in the AGR on the basis of the judgment be set aside, and respondent will have the liberty to raise the revised demand by treating the petitioner at par with the exempted PSUs having license to provide internet service. So what this judgment was saying was, if this NetMagic judgment, TDSAT said that if the PSUs were excluded by the Supreme Court judgment, the same logic should apply to the other PSU, other internet service providers, and they have to be treated at par. And that is the reason why this ISP license demand by Tata Communication by the DOT can also be defended because of this NetMagic case. Right? You understand now? So there are two different licenses. This NetMagic case actually provided a framework for making the ISP license, right, private ISP license, also at par with the PSU ISP license in regards to the AGR judgment. And that is the reason why, friends, the Tata Communication, who has the ISP license and the NLD license, they are saying that the company, based on its assessment and the independent legal opinion, believes that they will be able to defend its position. Now you get it, right? So this document, which is the Supreme Court judgment, it says that NLD license and the IP2 licenses are different from the USL and ISP license. Now, ISP licenses actually are at par with the USL license. Now, the PSUs actually had ISP license. But since ISP and the USL licenses are same, then how can the PSUs got away from the demand of DOT? Because they were providing non-commercial services, they were providing non-commercial services. You pause the video and have a look at it. Now, NetMagic went to the TDSAT and said that they require equal treatment compared to the PSUs. And the TDSAT says, yes, you are right. So if the PSUs can be bailed out by the Supreme Court, and there were some PSUs who were also providing commercial services, and therefore NetMagic should be given a similar treatment at par. The respondents will have the liberty to raise revised demand by treating the petitioner at par with the exempted PSUs having license to provide internet services. That's all, friend, in this video. I hope that you understood why Tata Communication is very, very confident in defending this demand of 7,800 crores of rupees, right, from DOT. Thank you, friends, for listening to that, and I'll come back with a new video on a new topic next time.